Greetings, Advocate Topping SC.
Greetings, CJ.
How are you, sir?
As usual, a little bit nervous, but I'm fine, CJ. Thank you very much for asking.
Okay, yeah. Okay, let's have a slow start so that you can get into it.
Yes.
You practiced as an attorney for about 3 years after admission, am I right?
Yes, I did 2 years articles, and I think it was 3 years as an attorney, and then I was 2.5 to 3 years as a prosecutor before joining the bar.
Yes. Why did you leave the attorney's profession for the prosecution?
I wanted to come to the bar, and in those days only advocates appeared in the High Court, and most of my practice as an attorney was in maritime law, where it was all in the High Court. So although I had experience as an attorney, I had no experience as it were on my feet in court, and I wanted to make sure I could do that. And I also had no criminal experience, and that's why I went to the prosecuting authorities and went there for 3 years to get court experience and get some confidence on my feet as it were to come to court.
Yes, and you've been an advocate in the private in private practice for about 28 years, am I right?
Yes, 1992. That's 28, 29 years.
Yes, and of those 28 years, you spent just over 6 as silk.
Yes, I took silk in 2014.
Yes.
Said on the previous occasion, I applied in 2012, and then there was a
Sure.
hold up of the applications because there was a challenge to the state president being able to bestow honors. So that was delayed for 2 years.
Yes. And have you been doing well in practice?
I hope so.
Notwithstanding the COVID challenges?
Well, can I say I'm comfortable? The COVID challenges very much. This last year, obviously, it's restricted a lot of appearances in court. But yes, thank you. My practice is fine.
Well, are you comfortable or very comfortable? You really don't have to be too humble.
Sorry, I couldn't hear that last bit.
I was saying, are you comfortable or very comfortable? You don't have to be too humble.
I don't think I can say very comfortable, but I'm comfortable. I'm comfortable enough. I live a simple life.
All right, okay. And you've acted several times as a judge of the High Court, am I right?
Yes, I have. Just as far as my acting is concerned, on the last occasion, there were some comments that maybe I hadn't acted long enough. So this year, with the constraints of COVID and obviously taking account of my practice as well, I've tried to act as much as I can this last year. I don't know if you want to know about my acting or what I've done and what I haven't done. But I think it is relevant for the commission to hear what I've done. I've now got some 11 months of experience as an acting judge. I thought that would be a little bit meaningless if you didn't know what I'd done during that time. So I went through my bench books and saw what type of work I've done. I've done over 50 opposed motions. I've done 13 trials, of which one is still a part heard. I've sat on 25 separate appeal benches. I've presided over motion court on 27 occasions, and I've scribed 37 written judgments, of which 2 are reported. That's what I've done during my acting career.
Thank you. Colleagues, may I have the names of those who have questions for the advocate?
Sigogo.
Nyambi.
Prof first and both. And Dodovu.
JP?
Thank you, Chief Justice. Advocate Topping, as you say, you have vast experience, both as a practitioner and on the bench. You acted, as you say, for 11 months.
Yes.
Yes. And my recollection is that it's both in the criminal and the civil courts.
Criminal appeals.
Yes.
I was due to do a criminal session before
COVID.
Christmas, but with COVID, then the criminal side, I reverted to a civil session.
And you say you prosecuted for a while.
Yes, well, for 2.5 to 3 years.
Yes.
That was after I was an attorney, and during the last, should I say, 18 months to 2 years of that prosecuting, I was what was styled as the specialist prosecutor, doing mainly commercial crimes and unpleasant crimes, should I say.
Now, with all your experience in the legal field, what do you say you could bring to the KwaZulu-Natal bench?
I've always, on my first interview and now, I've always been of the view, and I still remain of the view, that I can make a positive contribution to it. My mannerisms and my nature, I'm always prepared to hear two sides of the story. In practice, it's served me well because I'm able to debate and settle matters and civil matters and so forth. I've also tried during my acting time to allow counsel, especially junior counsel, to develop arguments. I've never tried to cut them short. I've tried to encourage junior advocates to be a little bit more relaxed in front of me. I've also tried to relax lay litigants and lay witnesses so they can tell their full story. I've had some positive feedback from that and from my colleagues. I've had no criticism in the manner in which I've conducted myself in court. That I think is a positive contribution. And also, as I just said to the Chief Justice, I've got a very high work ethic. And that will continue throughout. I don't leave things be. I finish them. If I have to work in the evenings, work over weekends, I get things done and I don't let things lie around. At that level, I think I can make a very positive contribution to the bench.
Other than the one part heard that I know of and you mentioned.
Yes.
There's no outstanding judgments.
No, there's two from the last session. I've got 2 reserves, which I'm scribing at the moment. I should have them finished in a couple of weeks.
How long have they been reserved?
From this last session, so it was from February.
I see. Since February?
Yes, sorry, February, March session. So they're not outstanding for too long. Everything else has been handed down. Well, when I say handed down, they're now published via email. But everything else has been finalized. I've got nothing outstanding except those 2.
As far as the work in the High Court is concerned, what challenges, if any, did you experience?
Comparing with practice, the challenges are kind of the same. To get through the work, to hear cases, to hear them efficiently, to hear them expeditiously. I think that is the challenge, is to try and get the workload out, because as far as I'm concerned, the most important person in the courtroom is the litigant. And they need to know that they've had a fair trial at the end of the day. And that's always a challenge, to get through the work in time. Just at that level, I don't know, again, if it's relevant, written works I do myself. I don't rely on secretarial services to type and so forth. And that's why I can get through a workload quite high, because I can work in the evenings, work over weekends if needs be. Yes.
Thank you, Chief Justice.
Thank you.
Thank you, Judge President. Honorable MEC.
Thanks, Chair. Just one question, the advocate, and good afternoon.
Good afternoon.
I'm this side.
So I'm backing to see.
This side.
Oh, sorry, I do apologize. Okay, thank you.
No, just one question. What offerings do you have insofar as transformation is concerned?
What have I done for transformation?
Should you also be given a chance, or should you be appointed?
Yes.
What novel things would you bring about to advance transformation?
What I have done in the past, and I think it's in the reports and so forth, I've been very involved in pupil training throughout my career. I've tried to impart whatever knowledge and experience I've ever had to the junior members of the bar. Right up to this last session, I actually myself and acting judge is going to sat on the bench on what they call mock trials to try and whether the pupils came and appeared before you and to take that through. I've been, or I'm on the Bar Council now as the senior silk, but prior to that, I was the pupil convener. When I first started, that was either 5 or 6 years ago. Myself, and I must say with a large measure of input from Commissioner Madunsela and erstwhile Commissioner Thandi Norman, we implemented a point system to, if anything, bring in the ills of the past and get the demographics right for the intake of pupils at the Durban Bar. Points were allocated on gender, on race, on experience, on qualifications, and that I think, and I would like, because it's still in place now, has transformed to an extent the intake of the juniors at the Durban Bar and transformed the junior demographics at the bar, and that over time will filter through the bar as those juniors get more and more experienced and more junior members join. As far as transforming on the bench is concerned, as I've said, my nature itself is just to try. When I first was a junior advocate, a courtroom was a very hostile on sometimes occasions, and always a very tense and unpleasant experience with some judges. I've tried to move away from that and make it, although always an air of decorum and control, but to make it more relaxed and let people tell their story, because that's the important bit, is that the litigant must feel that he had a fair, or she had a fair trial when they walk out of court. And at that level, and I hope I've transformed the ethos in the hearings that I've had. And also, if I am appointed, I would like to continue my association with training of junior practitioners. There, a lot of input, whatever experience I have got and whatever knowledge I have got, I'm very willing to try and impart to junior members. So at that level, I hope I can assist and move forward the court in Durban, or Pietermaritzburg.
Do you believe that we still have attitudinal problems in the system that probably may hamper transformation?
You say attitude problems?
Racial attitudinal problem.
I haven't come across. One hears stories of unpleasant stories, which I certainly do not support in any way whatsoever. But I think that the bench and the bar and all the professions are being transformed, but it's a process. The past was there for a very long time, and we need to work through that. But I've never come across, I get on very well with all my colleagues, all the members of the bench, no matter what race or gender or beliefs. I just make sure that I deal with everybody and I accept everybody for who they are and what they are. It's the way I conduct my life. So maybe that's why I don't get, or I haven't come across any problems at all.
Okay, thanks, CJ. Thank you so much.
Thank you very much.
Thank you, MEC. Commissioner Sigogo.
Thank you, CJ. Good afternoon.
Good afternoon. Good afternoon.
You left the sidebar,
yes,
to join the bar because your line of work was on maritime law, which is high court work.
Yes.
When you were still in Athens, did you brief black advocates to do maritime law?
At that stage, I don't think there were any, unfortunately, any black advocates that were skilled in maritime. It was a very close shop, if I might say so. And I'm talking back now to the 80s, the early 80s. That's when I was there. And also, when I say I was an attorney, I was an associate. So in other words, I wasn't running my own firm, and one does what one is told to do. But at that level, I'm just trying to think.
I think Judge Square was there as an advocate during that time.
Trying to remember, I think he might have, in matters I was involved in. But again, it wasn't me. It was obviously my principal were briefing, and I would be involved in the cases.
Let's come to the present.
Yes.
You indicated that there are some initiatives that you engaged with Advocate Madonsela SC,
Yes.
as well as Tandinoman SC.
Yes.
In those initiatives, do you include transference of skill in as far as maritime law is concerned to Black practitioners?
That was what we initiated, was purely a criteria for the intake. In other words, who should be accepted as a pupil member of the society. I must say, my maritime experience as an advocate is quite limited at the level. I haven't got a maritime practice, as it were. So at that level, but at the level of training pupils, I don't think there is any training as far as maritime law is concerned specifically. That kind of comes afterwards when one molds one's practice towards it.
One last question, CJ. Understanding that your maritime practice was not as active now as a council, but there, when you got 1 or 2 briefs, did you take along Black female advocates with you in order to transfer skills to them in terms of maritime law?
Okay, as far as maritime law, no, because I've never done big maritime cases as a silk. But as far as my silk's practice is concerned, and the general litigation that I do, very much so. I've always, whenever I can do, because one can't just demand a junior, try and encourage attorneys to brief me with a junior. And on most occasions, I can only think of 1 or 2 where it hasn't been, where it's been a white junior. I've tried to encourage, and a number of members of the juniors of the bar have been my juniors throughout.
Thank you, sir. Thank you, CJ.
Thank you very much.
CJ, may I be allowed a quick follow-up on Mr. Skogo's question on maritime law?
Please go ahead, President.
Thank you, CJ. Good afternoon, Mr. Topping.
So I can't pick up. Oh, sorry, I'm looking around the room. I apologize.
Look at the screen. I'm not in the room.
See, I do apologize.
Just one quick issue.
Yes.
If the appearances at the SCA in maritime law cases are anything to go by, then I just want to put to you that the area of maritime law remains very much a closed shop, because I've yet to see Black, well, we hardly see Black counsel in any case. But certainly in my 17 years there, I've yet to see a junior or even a pupil accompanying a counsel who've come to argue maritime law cases.
Well, that with respect needs to be addressed, because I'm going back to the 80s when my involvement was, and I don't like using the term closed shop, but I think that maybe proceeded through, and I agree with you, it ought to change. But
I'm sorry
I must also emphasize, at the level of the 80s, when the Act first came out, there was a lot of maritime litigation here, especially in Durban court. That has waned quite significantly because all people are now arbitrating in London and so forth. That volume of litigation in Durban especially has died down a lot, that I am aware of.
That is true. No, thank you very much, Mr. Topping. Thank you, CJ.
Thank you, and I apologize for not finding you initially.
Honorable Nyambi.
Thank you, CJ. Evening, Advocate Topping.
Good evening.
The last time you were here was in April 2018 for the same position.
Yes, it was. Yes.
You might be aware that you are competing with other 7 for the 3 positions available.
Yes.
So from 2018 April to date, anything that you think is very significant that we have to consider that you have done?
Just at the level, I've done much more acting. I've actually gone out of my way to try and take heed of those criticisms initially that maybe my experience on the bench was a bit limited. And especially this year, I've dedicated as much time as I can to acting and getting more experience on the bench.
Do you think now we are more ready than we were in 2018?
I'm more confident in myself and more confident that I can fulfill the functions, because with experience comes confidence. So at that level, yes, very much so. And especially this year, because I've had long stints where you kind of get into the swing of things, as it were. So yes, very much so. And I still feel I can make a very positive contribution if elevated.
I commend you for not giving up.
Pardon?
I commend you for not giving up.
Well,
Thank you.
It's always been a goal of mine. When I joined the bar, I wanted to finish my career on the bench, and I'm trying to achieve that goal.
Thank you, Advocate.
Thank you very much.
Thank you, CJ.
Thank you, Honorable Nyambi. Prof.
Good afternoon, sir. Thank
Good
you,
afternoon.
I've asked all the other almost all the other candidates their judicial philosophy. Would you mind sharing that with us, please?
So could you just elaborate?
Judicial philosophy.
Philosophy. So I don't really understand the question.
Well, what do you consider when you sit on the bench before you come to a final conclusion? What filters through your head? What is your judicial philosophy?
Or hopefully coming to the right decision eventually by applying the law. As I've said, my philosophy, and as far as practical is concerned, is that the most important person is the litigant. But coming to the right decision based on the law and the facts. I've always tried to achieve that. And I think one of the comments was from one of the reports I received dealing with the written judgments that I've done. The comment was that they are well reasoned and thorough. And that's what I've always tried to do, to make it, one reads what I've produced, to place you as close as you can to what transpired in court, what the law is, and that's why I've come to that decision. So if anything, thoroughness, I think, and coming to the right decision is very important to me.
Thank you. And the rule of law, what is your understanding of the rule of law?
Rule of law, well, we all before the law, we all before the Constitution. But it goes further than that. There's no one above the law, but it goes to also laws need to be certain, they can't be retrospective, and there has to be rationality and so forth. But much more that I think important is that everybody is subject to the law, no matter what you are or who you are.
Thank you, sir. Thank you, CJ.
Thank you very much.
Thank you, Professor. Advocate in both JSC.
Thank you. Good evening.
Good evening.
SC. Yes, I just would like to ask you one question. It relates to some of the issues that have been raised about what you call the cartels and all that in terms of the briefing patterns.
So I'm battling to hear you, sorry.
Sorry, okay, let me bring it closer. I was saying, I'm going to ask you one question which relates mostly to what you've been questioned about regarding briefing patterns.
Yes.
Which you've correctly pointed out have been skewed since the 80s until now. I wanted to test an idea, seeing that you're senior counsel. It is my view that senior counsel in particular have a considerable amount of weight on attorneys. In other words, if you insist, like I do, that I'm always going to have a Black woman as a junior in a matter, I'm sure one or two might say no, but by and large, people will go with what you're saying as the leader. So how can we harness that power to ensure that there's a real change? And I'll give you an example, excuse me, CJ. In Johannesburg, when I was the chair of the Bar Council, together with a few other people, we sponsored a rule that said, you may not have a team of 3 counsel, which are all white. So every head person must be a Black male or female, okay? As you can understand, when it came, there were all sorts of grumblings. But now it's practiced as second nature. People don't even think twice. It's, like the smoking laws. When it comes, people complain. But if you don't actually legislate, and my view is that maybe the time has come now for change that 3 counsel rule to a 2 counsel rule, to say you must in every team of 2, there must always be black or female counsel. And of course, I'm sure there'll be a whole lot of noise again, but it will go a long way into empowering hundreds and hundreds of people. Would you agree with that kind of approach? Obviously, there has to be consultation and all that, but that there should be, we can't just leave it to chance and the good hearts of people.
No, very much I would support that there has to be a transformation and skills transfer. In the old days, I don't know if I'm using the right term, but always you never briefed a silk without a junior. Those rules have kind of gone. There's economic pressures as to what the case is worth.
Yeah.
But very much so, it should be encouraged. Yes, a transformation and skills sharing throughout, and very much so the junior bar, because they filter up, become seniors, and that philosophy then follows all the way through. Yes, I'd very much support that.
Yeah, because we do agree that if there was a rule like that, then what President Maya is talking about would not happen.
Yes.
Because it would be in all those maritime cases,
yes,
there would then be at least skills transfer almost automatically.
Yes, it would happen automatically. Yes,
Yes.
and I agree with you and I support it.
Thank you.
Thank you very much.
Honorable Dodovu.
So thanks, CJ.
Thank you very much, CJ. I'm covered. I'm happy. Thanks.
Thank you, sir. Commissioner Tsepe.
Chief Justice, thank you. Good evening,
Good evening.
Advocate. I'm generally covered. The one thing I wanted to ask you as a follow-up on training, particularly of pupillage in a bar like Durban, you said that you do not cover maritime law. Why is that?
I honestly don't know. I'm no longer the pupil convener, so I'm out of that. And I'm talking off the top of my head. I'm not sure if it is covered or not. I think it's more, as far as the pupil training is concerned, it's more the basics of how to appear and the rules of court, those basics. And then maritime comes afterwards. But I don't think there's specifically, I really don't know.
Thank you.
Thank you.
Thank you, CJ.
Thank you.
Thank you so much, Commissioner Tsepe. Advocate Topiniasi, you are excused, sir.
Thank you very much, Chief. Thank you, everybody.
Thank you.